I don't know about, I'm not sure about the topic, so I'm going to make an inquiry today instead of giving my view. Judicial intervention in the arbitration. Is it an intervention or is it a support also? The inquiry started way back in 2005. One jurist, if I remember the name correctly, Liu, said that there must not be any judicial intervention. Another professor said, okay, then how we will enforce the award? I heard perhaps Preeti was saying something about the enforcement. So how you would enforce the award if a state legal support system or legal system support of the concerned state would not be there? If I go frame by frame, for the moment I'm trying to restrict my inquiry into the Indian domain, within the Indian legal domain. And gentlemen, if we go frame by frame, we talk about autonomy, party autonomy. Let me remind you that party autonomy is one thing, tribunal autonomy is the other thing to me. So by party autonomy, still you select the tribunal and it remains the adversarial system of the dispute settlement. So whether arbitrators should be left to decide in a way they want to decide, or they should also be bound by some piece of legislation, with especially where the arbitration is taking place or going to be enforced. Now, so to me, the legal system support is also very necessary. If you go frame by frame, if after the agreement between the two parties, still one party is opting to go court, we have Section 8. I'm not going to throw much section today, but we have Section 8. One party can move application and say, sir, don't hear him in a court or don't hear her in a court because we have a arbitration clause, arbitration agreement. At the time when tribunal has not been constituted and some interim measure would be required, some support of the judicial system is required for some interim measure. We have Section 9. Then if, despite of the agreement, the tribunal is not getting constituted because one party is not giving the consent or not appointing their respective arbitrator, what to do? You can reach to the court. I'm going to be very quick today in my inquiry. So even for the enforcement purpose, whether we require the support of the judicial system, judicial or legal system of the respective country or not, yes, you require. There are manifold problems. The problem, and there are very good piece of legislation. I know I heard Vijay said that endeavor word has been used for the international arbitration having seat in India. That's correct. That needs to be corrected. But the whole ecosystem in India with respect to arbitration is evolving. And 2015 and 2019 amendments clearly indicate that we have an intent to go further. Let us examine the delay per se instead of calling it as a judicial intervention. So definitely the first reason for delay is, if you ask me, in the pre-arbitration zone. Why court should take a 1 year or a 2 year in appointing the arbitrator? That is correct. For that purpose, the whole of the ecosystem has to evolve. The Supreme Court need to be careful about the same. Sometimes courts are going into the inquiry whether per se this dispute is arbitrable or not, and therefore I should appoint the arbitrator or not. With due respect to my mind, that is not the correct inquiry. If there is an arbitration clause and dispute exists, arbitrator must be appointed. And then on the jurisdiction, Section 16 is there, arbitrator can speak about its own jurisdiction. We need to literally work on it. This is one issue. Second issue, already Government of India, conscious of the paper was circulated a couple of days back inviting the comments, is definitely about the arbitration, about the enforcement, I'm sorry. Regarding enforcement, the biggest challenge which I can see is the original site jurisdiction in a different part of the country is different. I mean, sometimes we can go to High Court and at some of the places to challenge the award. At some places we need not to go to the district court. And with due respect, no offense I'm intending at all, but perhaps at the district court level, more training is required if you still want to keep the original site on limited jurisdiction at district court. In a complex dispute, especially if I focus for a minute on a complex dispute, the honorable judge who is examining at the district court level especially, or any court level, I mean, let me say that, I mean, there can be subject matter constraint. So that's why first principle of the appeal, perhaps which is across the globe, and Indian Supreme Court has recognized that, please don't replace your view in place of the arbitrator view. That is correct. But think of the situation, and I'm not saying anything, I'm asking you to think over it. What is the status of the law of perjury in this country? Think over it. Have you ever come across a judge from your side, or I'm sorry, from the expert, maybe the subject matter expert or the fact witness coming on oath before the arbitrator and deposing something which is incorrect, erroneous, wrong, and what is the status of law of perjury? I mean, I don't think anybody is quite serious about somebody speaking incorrectly on oath in the arbitration. This leads to what? A subject matter expert coming, telling something contrary to the established practice, norm, etc. and etc. How to handle that? Judges across the globe are not expert of all the subject matter. It is not possible, gentlemen and my friends. It is not possible. Some self-discipline is also required. Let us take another example which leads to delay. And again, my lawyer friend will not take an offense at all. I'm not intending. How many times we honestly advise to the client that please don't go to section 9, please don't go to section 34, there is nothing in it. Because everybody knows that somehow, relatively, the litigation may be cheaper here, and chances in going into section 9 and section 34 and section 37, approaching the court at a different stages, may not lead to award of complete cost against them if they lose the appeal or application. So this delay is due to the complete ecosystem which is evolving. I'm not complaining at all. I'm saying it is evolving. The Government of India is conscious of. Now see the good side of it. The good side of it is that though some of my friends have disagreed that there is a time-bound arbitration, but there is a time-bound arbitration. The complex disputes are getting resolved. The pool of arbitrator and pool of lawyers are small. That is one problem. Like for example, somebody was telling about the renewable. The renewable energy is having a quite number of litigation, arbitration. I mean, even lawyer need to be trained about asking a question in a cross-examination to the subject matter expert. So the whole ecosystem, the lawyers are getting trained in the process of arbitration. The arbitrators pool is expanding day by day. It will expand further, I'm sure about it. And somewhere the law of perjury need to be tightened up or to be considered seriously. And the cost awarding criteria must be more relaxed, liberal. Cost shall be awarded. If anybody is going to the court challenging in section 934 or 37 or international arbitration filing in section 48, Court should be conscious of awarding the cost. The party who is approaching to the court must be conscious of that, okay, if I will lose, I need to pay the other side cost also. Courts are intervening. I mean, definitely, we have a logistic problem to a certain extent. Courts are overburdened, I agree. There are delays, I agree. But we need to think how many delays are due to the party's conduct also. Gentlemen, nothing is my position, this is inquiry. How many times we unnecessarily instruct the counsel to go to section 9 for some strategic reason, for etc., 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 and the cost is less. So, lastly, I mean, I must say that there is a very restrictive pool of arbitrators, trained arbitrators. To me, that is the biggest problem. Sometimes the so-called expert, with due respect, they are deciding the case without giving any weightage to the law. I mean, at the end of the day, I'm sure nobody is arguing here or nobody is commenting here that we must go for the arbitration in disobedience to Indian law. Can't be. Section 23 is very clear into the Contract Act. Any contract which is against the law cannot be enforced. That is the Indian law. Please don't ask me to, somebody should argue that, no, we should change section 23 also. No, will not. I am not at least advocating that. So, and this is known as, in the words of Professor Richard Thamer, Chicago University, this is a question of choice architecture. You made the choice to do business in India. Indian law shall be respected. The basic four corners of the law, equity, conscience, illegality, irrationality, proper procedure, these need to be respected, and I'm sure in every jurisdiction it is getting respect as per as the local laws are concerned. So, the problems are there. Kindly see the brighter side. Whether the judicial intervention is same as it was 15 years back, answer is no. And here lies the hope. There is a light at the end of the tunnel, gentlemen. We are a couple of years away, definitely, but we'll be there. Courts, please, anybody after this conference, write me back how many times you have seen that courts have restrained the arbitrators in an ongoing arbitration to go ahead. Rare. There are certain awards which has been set aside by the superior courts. Sometimes you will agree that it is correct. There was an error. So, therefore, what to do? The people who are practicing in India especially, I mean, my request would be, friends, we should create some kind of environment where we should feel responsible also towards client in advising them when to approach court. It will lessen the burden. Perjury law should be looked into again. Cost measures should be, cost should be avoided by the court, no argument on that. And then issue is of enforcement. Enforcement, with due respect, enforcement must not take 5 years, 3 years, 4 years. That is a pain. Before that, I think we are falling in line. The only problem is enforcement, on which the government of India, thinking very loudly. There is a paper, you must, all of you must have seen it, and we are going to be, some kind of measures are coming for the enforcement. It cannot be years to be in the court. Then, my one request is that in the name of the institutional arbitrations or institutions for the arbitration, please don't make the rules so complex that for the purpose for which arbitration was envisaged at some point of time as an alternative dispute resolution platform may lose its relevancy. So on that note, thank you very much. Thank you very much for hearing me and inviting me here. Thank you very much, everybody.